Gun control states thought they had time. Then one 6-3 Supreme Court ruling turned decades of permit strategy upside down, and the aftershocks are still moving through New York, California, Hawaii, New Jersey, and beyond. This is not just a legal story for lawyers in dark suits or judges reading old cases in marble buildings. This reaches into your daily life faster than most people realize. It affects whether your state can decide who gets to carry a handgun in public. It affects how police handle public carry. It affects how businesses post rules on their doors. It affects whether lawmakers can respond to fear with tighter rules or whether courts will strike those rules down. And if you think this only matters to gun owners, think again. When a Supreme Court decision changes the balance between individual rights and state power, that shift never stays in one lane. It spills into public safety debates, election messaging, policing, insurance costs, local business policies, and the way entire communities think about risk. What happened here is simple on the surface and explosive underneath. For years, some states used a system that said you could not just apply to carry a gun in public and expect approval. You had to prove a special need, not a normal fear, not a general desire for self-defense, a special reason. Then in June 2022, the Supreme Court said that framework went too far. By the end of this video, you will understand exactly what happened, why it matters, what gun control states did next, and what to watch for now as the next legal battle moves closer. The case was New York State Rifle and Pistol Association versus Bruen, decided on June 23, 2022. The vote was 6-3. Justice Clarence Thomas wrote the majority opinion, and the core question was brutally direct. Can a state force an ordinary law-abiding citizen to show a special reason before carrying a handgun in public for self-defense? New York said yes. The court said no. To understand why that hit so hard, you need to know how New York's old system worked. The state required applicants for an unrestricted concealed carry license to show what it called proper cause. In practice, that meant more than saying, "I want to protect myself." New York courts interpreted that phrase to mean a special danger, something beyond the ordinary risks everyone faces. A pattern of threats, a unique job, a specific problem. If you could not show that, the government could deny you. Supporters said that kept guns out of crowded spaces and gave local officials flexibility. Critics said it made a constitutional right depend on whether a licensing officer liked your explanation. And that is where the tension exploded. The Supreme Court majority did not just strike down one rule. It changed the legal map. According to the opinion, the Second Amendment protects an individual's right to carry a handgun in public for self-defense, not just inside the home. That matters because earlier gun rights cases had focused heavily on the home. Bruen pushed the argument outward into streets, sidewalks, stores, and daily life. The court said the Constitution's text covers bearing arms, and bear most naturally includes carrying in public. That was the first shockwave. The second was even bigger. The court rejected the balancing test many lower courts had been using. Here is the plain English version. Before Bruen, many judges looked at two things. First, does the Second Amendment even cover this conduct? Second, if it does, is the law still reasonable because it helps public safety? That second step gave states room to argue that even if a law burdened gun rights, it served an important goal. Bruen said that was the wrong approach. The new rule was this: if the conduct is covered by the text of the Second Amendment, the government has to prove its law fits this nation's historical tradition of firearm regulation. In other words, the state cannot just say, "Trust us, this is good policy." It has to say, "We can point to a real historical tradition that is similar enough." And that is where gun control states really did not see the full impact coming. Because once the court changed the test, dozens of laws suddenly had to survive a new kind of attack. Not just assault weapons bans, not just magazine limits, not just licensing rules. Everything from location bans to age restrictions to public transit carry rules was now being relitigated through history. Judges were suddenly asked to compare modern gun laws to regulations from the 1700s and 1800s. Think about how strange that is. It is like asking whether today's smartphone privacy rules should depend on what people did when letters arrived by horse. That does not mean history is irrelevant, but it does mean the courtroom became a battlefield over which past matters and why. The majority did leave important room for regulation. That part often gets lost in the shouting. Justice Brett Kavanaugh, joined by Chief Justice John Roberts, stressed that states can still use shall-issue systems. That means objective rules like background checks, fingerprinting, mental health record checks, and training requirements. The court also repeated language from earlier decisions, saying long-standing bans on possession by felons and the mentally ill can still stand, along with restrictions in sensitive places like schools and government buildings. So if you were told Bruen instantly erased every gun law in America, that is not true. But if you were told Bruen was a narrow case about one New York permit form, that is also not true. The truth is more important and more disruptive. The court kept regulation alive, but changed the rule book for defending it. So why did this hit certain states harder than others? because several states had systems similar to New York's. California, Hawaii, Maryland, Massachusetts, and New Jersey all had versions of discretionary permitting, where officials had broad power to decide whether your reason was good enough. Once the court blew up New York's proper cause rule, those states were immediately exposed. Their legal defenses were suddenly weaker. Their lawmakers had to move fast. Their attorneys general had to rethink what they could still save. And their opponents knew they had momentum. Ask yourself this. If you were a state official who had built policy around official discretion for years, what would you do when the Supreme Court says ordinary self-defense is enough? The dissent, led by Justice Stephen Breyer and joined by Justices Sonia Sotomayor and Elena Kagan, warned that the majority was underestimating the real-world cost. Breyer pointed to the scale of gun deaths in the United States and argued that states need flexibility to respond to local conditions. In simple terms, the dissent was saying this: New York lawmakers are closer to the problem, they know the risks in dense urban spaces, and the court should not tie their hands so tightly. That argument resonates with millions of Americans who look at mass shootings, street violence, and daily fear and ask why courts would make it harder for states to experiment with solutions. But the majority saw a different danger. It saw a system where a constitutional right existed on paper, but could be denied in practice unless a citizen proved they were unusually worthy. That clash is the heart of this entire story. But here is what no one should miss. Bruen was not just about guns. It was about discretion. It was about who gets to decide when your rights become real. If a right can be delayed until you show a special need, is it still a right for everyone or only a privilege for the convincing? That question is bigger than one amendment. And it is why this decision landed with so much force. Then came the next phase, and this is where the states tried to adapt. New York moved first. Governor Kathy Hochul called an emergency legislative session, and lawmakers passed the Concealed Carry Improvement Act, often called the CCIA. The state no longer relied on the old proper cause language. Instead, it built a new framework. Applicants had to meet a good moral character standard. They had to provide more personal information. And the law declared a long list of sensitive places where licensed carry was banned, including places like schools, houses of worship, hospitals, and other designated spaces. The law also created a major default rule for private property open to the public. Unless the owner expressly allowed guns, carry was prohibited. That was the counterpunch. And if you are following the chessboard, you can see the strategy. If the court says we cannot block ordinary people by forcing them to prove special need, maybe we can still narrow where they carry, how they qualify, and what counts as lawful space. Supporters of these new laws said states were simply doing what Bruen itself allowed, regulating sensitive places and setting objective conditions. Critics said this was open resistance dressed up as compliance. In their view, the state had lost the big fight and was trying to win by slicing the public square into so many restricted zones that the right existed mostly on paper. Which side is right? That is exactly the question courts have been wrestling with ever since. If you're finding this breakdown useful, subscribe now and turn on notifications. We track these developments in real time, and the next update could change the entire picture. Now let's go deeper into what's really driving this legal crisis, because the biggest fight is no longer over whether Bruen was dramatic. It is over what Bruen actually means when real laws meet real streets. The deeper problem is that Bruen gave lower courts a command, but not a clean manual. Judges were told to look for historical tradition. Fine. But what history matters most? Is the key year 1791, when the Second Amendment was ratified, or 1868, when the 14th Amendment made it apply against the states? How similar does an old law have to be? Does a ban on guns in a courthouse support a modern ban in a subway? Does an old anti-poaching law on private land justify a default no-carry rule for every shop, cafe, and parking lot? These are not minor questions. They are the entire game. By 2024 and 2025, lower courts were split, cautious, and often frustrated. In New York's post-Bruen litigation, the Second Circuit allowed parts of the new law to stay in effect while striking or questioning others. The private property default rule drew especially serious skepticism because it could apply to huge amounts of land open to the public. At the same time, the court allowed many sensitive place restrictions and most of the broader framework to continue, at least while litigation moved forward. That mixed result tells you something crucial. Gun control states did not collapse overnight, but they also did not get the easy workaround they wanted. They entered a long war of attrition, one courtroom at a time. And New York was not alone. Hawaii passed a similar private property rule. So did other states, including California, Maryland, and New Jersey, in different forms. Why does that matter? Because when several states try the same response, the Supreme Court eventually notices. One state can be treated as an outlier. 4 or 5 states using the same legal playbook start to look like a test case for the entire country. That is why the Hawaii case, Wolford versus Lopez, matters far beyond Hawaii. The issue is whether a state can presumptively ban licensed carry on private property open to the public unless the owner gives express permission. That sounds technical. It is not. It affects malls, restaurants, stores, parking lots, and countless everyday spaces. In practical terms, it decides whether licensed carry is the default or the exception. Now, here is the twist that makes this even more complicated. In June 2024, the Supreme Court decided United States versus Rahimi by an 8-1 vote and upheld a federal law that bars people under domestic violence restraining orders from possessing guns. That is a major point because it shows the court is not saying every gun restriction must fall. The court said history supports disarming people who pose a credible threat. So the message from the justices was not states lose everything. The message was narrower and in some ways harder for everyone. The government can regulate, but it must tie modern laws to a historical principle the court accepts. That sounds manageable until you try to do it across 50 states, modern cities, and weapons the founders never imagined. For ordinary people, this legal fog has real consequences. If you are a gun owner in a state like New York or California, the question is not just whether you can get a permit. It is where that permit still means something. Can you carry while picking up groceries? What about in a church parking lot? What about a privately owned cafe open to the public? If you are a business owner, you face a different problem. Do you post signs? Do you invite conflict? Do you accept the state's default rule or your own judgment? If you are a police officer, you are stuck enforcing rules that may survive 1 month, get narrowed the next, and be challenged again after that. If you are a parent worried about violence, none of this feels abstract. It feels like adults with power are arguing over history while communities live with present danger. That is why the next 12 to 24 months matter so much. The Supreme Court declined in 2025 to hear major challenges to Maryland's semi-automatic rifle ban and Rhode Island's large-capacity magazine ban. Some viewers hear that and think case closed. It is not. Justice Kavanaugh signaled that the court will likely address the AR-15 issue soon, perhaps in the next term or two, after more lower courts weigh in. Translation, the justices may be waiting for a cleaner vehicle, more developed rulings, or a sharper conflict among appeals courts. In plain language, the court is not retreating. It may simply be loading the next round more carefully. So what is really driving the crisis now? It is not one case. It is the collision between three forces. First, the court has constitutionalized public carry more aggressively than before. Second, gun control states are trying to preserve as much regulatory control as they can without directly repeating the old systems that got struck down. Third, lower courts are still trying to figure out how to apply a history test to a modern country with urban density, mass transit, digital threats, and a gun market unlike anything in the 18th century. When those three forces hit each other, you get legal instability. And instability is where politics, fear, and litigation feed off one another. Think of it like a referee changing the rules in the middle of a championship game. One team had built its whole defense around a certain interpretation. Suddenly, the referee says that move is illegal, and from now on, a different standard applies. The team does not just stop playing. It adapts. It shifts positions. It tests new boundaries. The other team attacks the new formation. Meanwhile, the crowd is screaming, the coaches are furious, and nobody is fully sure how the next call will go. That is where Second Amendment law sits right now. Here is the part many headlines miss. The states were not blindsided by the existence of gun rights arguments. They were blindsided by how broad the legal aftershock would be. A lot of officials likely expected the court to strike New York's specific permit rule and leave the rest of the framework largely intact. Instead, Bruen turned historical analogy into the central test. That one move gave challengers a weapon against a much wider set of laws. It shifted the burden onto the government. And once the burden moves, the momentum moves with it. Let me ask you a direct question. If your state passed a law tomorrow saying you can exercise a constitutional right only after proving exceptional need, would you trust officials to apply that fairly? Or would you worry that politics, class, geography, and simple bias would shape who gets approved? Your answer to that question probably tells you how you see Bruen more than any cable news segment ever could. Drop your thoughts in the comments below. Do you think states are protecting public safety, or do you think they are trying to rebuild the same barriers under new names? Your perspective helps us all understand this faster. While you're thinking about that, consider this next piece of the puzzle, because the end game here is not just about permits. It is about what kind of constitutional order the court is building. The most likely scenario is a narrowing, not a total wipeout. That means the Supreme Court could continue allowing objective licensing systems, training requirements, background checks, and genuine sensitive place restrictions, while striking down state rules that make public carry practically impossible through defaults, vague standards, or giant no-carry zones. In that world, states keep real power, but not unlimited power. The government can regulate the edges, not erase the center. If that happens, gun control states will still have tools. They will just have to be more precise, more defensible, and more honest about what history actually supports. The worst-case scenario, depending on your point of view, is broader legal chaos. If the court keeps using strong language but gives weak guidance, lower courts will continue splintering. Some judges will read history narrowly and strike down law after law. Others will accept looser analogies and uphold sweeping restrictions. That would create a patchwork America where your rights and your restrictions change dramatically when you cross a state line, or even when a different federal appeals court gets the case. For citizens, that means confusion. For law enforcement, it means uncertainty. For lawmakers, it means writing laws under a cloud of likely litigation. And for businesses, schools, and communities, it means policy becomes a moving target. Then there is the wild card. The court could decide a case like Wolford and use it to clarify far more than private property rules. It could finally tell lower courts how close a historical analogy must be. It could say whether the key benchmark is 1791 or 1868. It could explain how to think about places that did not exist in the founding era, like airports, subways, stadium complexes, or modern hospitals. If the court does that clearly, the legal fog could start to lift. If it does it vaguely, the fog gets thicker. And that may be the most important warning of all. Not every Supreme Court decision settles a fight. Some decisions simply move the battlefield. So what should you watch in the news this week and in the months ahead? First, watch how the court talks about private property open to the public. That issue sounds narrow, but it is one of the cleanest tests of whether states can turn carry into a permission by default system again. Second, watch whether the justices take up an AR-15 or large capacity magazine case after more appeals courts rule. That will tell you whether the court is ready to move from public carry to the hardware question. Third, watch the language around history itself. If future opinions explain which era matters most and how analogies should work, that will affect almost every gun case in the country. Also watch the politics. Legislatures in restrictive states are learning that symbolic laws can backfire if they are too aggressive and invite fast court losses. Gun rights groups are learning that winning a headline case is only the start. The real work is fighting through the follow-up laws states pass to limit the damage. And voters are learning something that often gets hidden in legal coverage. Courts do not replace politics. They redirect it. When one strategy gets blocked, another appears. When one phrase gets struck down, another gets drafted. The conflict does not disappear. It mutates. That is why this story matters whether you cheer the ruling or fear it. For gun rights supporters, Bruin was a major victory, but not the final one. States are still fighting, and some restrictions remain very much alive. For gun control supporters, Bruin was a serious loss, but not total defeat. The court has also shown in cases like Rahimi that dangerous people can still be disarmed, and that some regulations remain firmly constitutional. The future will be decided in the gray zones between those positions. And gray zones are where law, politics, and public emotion usually become most volatile. So when you hear someone say gun control states never saw this coming, there is truth in that, but not in the simplistic way viral headlines sell it. They saw a challenge. They may not have fully seen the scale of the doctrinal shift. They may not have expected one permit case to trigger a nationwide fight over history, sensitive places, private property, and the very method judges use to review gun laws. That was the real surprise. Not just the loss, but the chain reaction. And that brings us back to the opening point. One Supreme Court decision did not end the argument. It exposed the real argument. Who decides the limits of a right before harm happens? The citizen, the state, or the court reading history from another century? That question is now moving through America one case at a time. Stay alert, watch the next rulings closely, and if you found this breakdown valuable, subscribe for our next deep dive. We're already tracking the next development, and it could change everything.